Hey guys, Alex Newman here with the New American. We're at CPAC, and with us we have Chris Sevier. He is an attorney with De Facto Attorneys General. They're working on some really important stuff. They litigate in the courts and then get legislation to make sure it doesn't get struck down in the courts. Chris, thanks for being with us. And you guys are working on a number of really important projects. The one that really I thought we should start with is the Stop Woke Act. That's been introduced here in my state. It's designed to protect, I guess, employees and students from the brainwashing that's going on in the public schools and from the big corporations. Tell us, what was you guys' role in that? Why'd you do it, and why do you think it's important?
So basically, what we did is the way we came up with that is we sued Mayor Bowser in federal district court in D.C. for displaying the Black Lives Matter banner on 16th Street. And we basically said that BLM is a religion. It's a cult. They have the What We Believe section on their website. They have these incantations, and they basically advance what's called, a series of unproven faith-based assumptions and naked assertions that are implicitly religious and inseparably linked to the religion of secular humanism. So it was from that litigation that we put to paper what we call the Stop Woke Act, which basically is a bill that says, pursuant to the Establishment Clause of the First Amendment of the United States Constitution plus the state's constitution, the state is prohibited from creating enforcing any policy. Public school is prohibited from creating or enforcing any policy that respects or endorses critical race theory, because it violates the principles of separation of church and state. The Supreme Court found in Torcaso versus Watkins that secular humanism is a religion, and critical race theory is inseparably linked to that worldview. And just like a public school can't impose Christian views on children, I'm a Christian, I want the school to be neutral as to Christianity. We want the school to be neutral as to critical race theory. We've codified a thing called the Lemon Test, which is what the courts use to determine whether or not the government's entangling itself excessively with religion. And the thing about framing things as religion, it's the one area of the law where taxpayers can sue if they have a logical nexus. So the bills that we have would say a parent of a student with a logical nexus. So like, let's say a parent's child's being, indoctrinated with CRT by a public school. The parent, pursuant to the statutes, the Stop Woke Act, would have standing to file a lawsuit where they could seek injunctive relief and they could seek attorney's fees. And that's the enforcement mechanism. So we've invoked the Establishment Clause. We frame things as religion. We codify the Lemon Test. We allow the parents to sue. That's the enforcement mechanism. And we allow them to recover attorney's fees so they'll actually do it instead of having to go out of pocket. So that is a quick overview of the Stop Woke Act.
That's fascinating. And where do big corporations come in? Are big corporations prohibited under the law from like pushing a religion on their employees? Or because if I'm not mistaken, the Stop Woke Act, it's not just for public schools. It also affects what corporations can do to their employees. Is that right?
Well, so the thing about, there's different versions of different bills. So the one we have is narrowly dealing with schools. I would say that if there is a corporation that is, there's Title VII, which like basically if you have a business that has more than 15 employees, if you're discriminating on the basis of religion, then the person who's being discriminated against will have standing to sue pursuant to that federal statute. So that's kind of covered by that. But what we're focusing on is government actors, that are funded by taxpayers. And we're framing the left for what it is, whether we have the School Establishment Clause Act, which just gets rid of all the LGBTQ doctrines and policies out of public schools, or the critical race theory. It is religion. The left is basically advocating a series of unproven faith-based assumptions and naked assertions that are implicitly religious and inseparably linked to the religion of secular humanism. And we also make clear in our bills that you can believe, pursuant to the First Amendment Free Exercise Clause, an individual, a teacher or student can believe in LGBTQ ideology, critical race theory, but the government cannot promote it. It cannot, sponsor it, endorse it, or respect it. It has to be neutral as to concepts like that are completely divisive and also a lot of times promote licentiousness. And it are very obviously just an attempt to justify practices that are inconsistent with the peace and safety of the state. The very idea that children are involved gives us extra oomph to be able to really regulate that, to stop it. And we want parents to be able to be the enforcement mechanism. So we let parents do, pursuant to taxpayer standing, doctrine, logical nexus doctrine. We've codified all of that in a way that, if enacted by the different states, will survive judicial review. The bill language has been written for all 50 states. It's on the website, specialforcesofliberty.com. And I would really encourage your listeners to go to specialforcesofliberty.com. Look at the bills for their individual state, download them and send them to their state senators and state representatives, especially those on the Judiciary Committee or those on Education Committee. Now, we've teed this up a lot. We've met with state representatives throughout the country. You name a state, I don't think we've been to all of them. But they really need to hear from local constituents telling them that they want these bills to become law in their state.
That's awesome. And give us an overview of some of the other bills. You guys said you had 7 key ones that you're working on. Give us an overview of a couple of the crucial ones.
So let's talk about the social media. It's called the Social Media Accountable Censorship Act, the SMAC Act. And the reason I want to talk about this is because it is the only way to stop social media censorship. If this bill is enacted as we've prepared it, it will survive in federal court. It will not be preempted under what's called the doctrine of preemption. So we've sued tech a lot. And from the litigation, we've come across Section 230 defenses, and we know how to get around it. There's a thing built into Section 230, the Communications Decency Act, which is basically a shield that allows for third parties to have immunity, allows internet intermediaries to have immunity from the acts of third parties. We actually think that that's good law. The way to understand it in English would be if someone posts a defamatory comment on YouTube, the defamed party could sue the person they defamed them. But if they sued YouTube, YouTube could invoke a Section 230 immunity defense. That's a good use of it. But what's happening is social media has been censoring Christian conservatives and then turning around and invoking this immunity defense. Okay, that's an abuse of that. But built into Section 230 is what's called the State Law Exemption. It's subsection E, subparagraph 3, that says if the states would enact a statute that would narrowly parallel the spirit of Section 230, then it will not be preempted by the doctrine of preemption. So it's all kind of like we're dealing with imaginary stuff, right? You can't see any of this. The doctrine of preemption, Section 230, this shield, but the stuff is real. These are real laws, and there's ways to get around them to cure abuses. And so that's what we've done. We've framed the Social Media Accountable Censorship Act. We've written it for all 50 states. If you live in a state where you want to stop social media censorship, we're imploring you to go to Special Forces of Liberty, download the language for your state, take it to members of the Judiciary Committee, Republicans, and ask them, tell them that you vote in their state, you live in their state, and you want that to be drafted and enacted.
Awesome. And there's a couple more. You want to just give us a quick word on them?
Yeah. So we have. Let me talk about a human trafficking bill. We have a bill called the Save Our Children Act, okay? It's a bill that we wrote out of an enormous amount of litigation against big tech. It basically says going forward in a state, a retailer of an internet-enabled device, that means like laptops, ISPs, and so forth, before the products leave with the consumer, they're going to have a filter installed that automatically block by default websites that are known to facilitate human trafficking and prostitution, and websites that display X-rated material that would be injurious to children. If the consumer is an adult, they want to have access to adult websites, they can. They just got to show proof of ID for the retailer and pay whatever fee to remove it that the retailer asks. And then they'll have the internet like it is right now. But we have language on that that's very specific that we know that will be upheld in court. And we rely on cases like Ashcroft versus the ACLU, where the Supreme Court found that the legislative branch may undoubtedly act to encourage the use of filter. It can encourage parents to use filters and the tech companies to develop better filter technology. So we would put like that Supreme Court as a legislative finding in the bill so the legislatures will know we're relying on controlling precedent when we give them the language. Another case would be Ginsburg versus New York. And that's basically a Supreme Court decision that says the display statutes, which 48 states have, is constitutional. That's the statute that requires a gas station to put X-rated material behind a blinder rack that can only be removed if the consumer is an adult. They show proof of ID. So what I want to emphasize is that we are Christian, conservative, constitutional federal litigators. We go to court and fight on these topics. And from the litigation, we put to paper the answers for how to, like the legislative solution. If these bills are then enacted and they go to court because we're relying on so much existing controlling authority, the courts cannot strike them down. And so, but what we're lacking is we need more locals, your viewers, to download the bills and take it to their state. So,
that's awesome. Yeah. Well, Chris, we appreciate it. Give us the website again, specialforcesofliberty.com.
Yeah, specialforcesofliberty.com. And, we're not promoting that because we want to promote ourselves. We are irrelevant. When a House or Senate member runs the bill, it's their bill. Okay, they are the authors, but that is the website where the language can be found. There's also lots of videos that kind of explain the gist of some of the bills. And there's also, if you really want to go deeper in the weeds, there's a lot of our pleadings from litigation, so you can see the legal arguments supporting it. But yeah, that's it.
Well, Christopher Sevier, we thank you very much for all that you're doing. Thank you for being here with us. And I hope people will go check it out, specialforcesofliberty.com. Thanks again.
One last thing, and that is the best people in the country follow y'all's station. So we really appreciate what you guys are doing.
Hey, thank you so much. We appreciate that too, Chris.